Hello everyone, this is your host Urvashi Chauhan. Welcome back to another episode of Courts Today by Livelaw, your one-step destination to all legal developments in the country. Let us start. Starting with an important update from the Supreme Court. The Delhi government today requested the Supreme Court for an early hearing of its petition challenging the law taking away services from the control of the Government of National Capital Territory of Delhi. If you remember, a year back, the top court referred the Delhi government's petition challenging the Government of National Capital Territory Amendment Ordinance 2023 to a 5-judge constitution bench. The ordinance was replaced by the Government of NCT of Delhi Amendment Act 2023, passed by the Parliament in August last year. The writ petition filed by the Delhi government points out that this was brought out a week after a constitution bench of the Supreme Court pronounced that the Delhi government has power over entry 41 of list 2, that is services. It is argued that through the same, the central government has in effect overturned the Supreme Court's verdict. The act is challenged as violating the scheme of federal democratic governance and that it negates the primacy of the elected government. Senior advocate Dr. Abhishek Manu Singhvi, appearing for the Delhi government, stressed the need for an urgent hearing as the law was creating hindrances on the state's administration at the ground level. He mentioned about the earlier decision of the court which held that NCT of Delhi has legislative and executive power over administrative services in the national capital, excluding matters relating to public order, police and land. He urged that adjudication on the present matter would aid in ironing out the creases. The Supreme Court today found it disturbing that the Directorate of Enforcement had still not completed the investigation in the 2015 Nagrik Apurti Nigam or the NAN scam case concerning corruption in the public distribution system in Chhattisgarh. The ED has challenged the anticipatory bail granted by the Chhattisgarh High Court in 2020 to accused Alok Shukla and Anil Tuteja, the then chairman and managing director of NAN. ED argues that they are misusing their anticipatory bail. Let me tell you, in 2015, the Anti-Corruption Bureau had registered the FIR against Shiv Shankar Bhatt and 26 others, including Tuteja, for alleged offences under Prevention of Corruption Act and the IPC. In 2022, the Enforcement Directorate, claiming collusion between accused and authorities, submitted before the Apex Court that a High Court judge was in touch with people who were helping the accused. A bench of Justice Abhay S. Oak and Augustine George Massey pointed out the previous order in which ASG SV Raju's statement was recorded that ED will file an affidavit to support the contention that Tuteja and Shukla are misusing the anticipatory bail. The court further questioned as to what the judiciary has to do with the allegation that the accused are misusing the anticipatory bail. The court has now granted 2 weeks' time to ED to file an affidavit to show how the accused are misusing their anticipatory bail. In the next update, ANI Media Private Limited has filed a suit against Wikipedia before the Delhi High Court over allegedly defamatory description of the news agency. Wikipedia's page says ANI has been criticized for having served as a propaganda tool for the incumbent central government, distributing materials from a vast network of fake news websites and misreporting events. Advocate Siddhant Kumar, appearing for ANI, told the court that the content mentioned in the description is defamatory. He said that Wikipedia, which is an intermediary, is a platform which is now used as a public utility and cannot behave as a private actor. Kumar further said that Wikipedia had closed ANI's page for editing by the news agency except its editors. ANI has thus sought to restrain Wikipedia from publishing allegedly defamatory content on the news agency's page on its platform. It has also sought removal of the content and 2 crores as damages. Justice Naveen Chawla issued notice on ANI's plea. He orally remarked that Wikipedia is entitled to have opinions and that it will explain its actions before the court. The matter has been listed for hearing next on 20th August. And now an update on the Gyanvapi dispute. A bench of Justice Rohit Ranjan Agarwal of the Allahabad High Court today heard a civil revision plea filed before it challenging the Varanasi district judge's order from October last year, which refused to direct the Archaeological Survey of India to undertake a survey of the Wazukhana area except for the Shivling inside the Gyanvapi mosque. The revision plea has been moved by Rakhi Singh, who is plaintiff number 1 in the Shringar Gauri worshipping suit 2022, which is presently pending before the Varanasi court. In her revision plea, Singh stressed that the survey of the Wazukhana area is necessary in the interest of justice. It shall benefit the plaintiffs and respondents alike. During today's hearing, Justice Agarwal questioned Singh's counsel about the need for an additional survey, considering that the ASI had already completed a survey of the mosque premises and submitted its report. Advocate Tiwari responded by emphasizing the necessity of a further survey to determine the site's religious character. He also argued that it is possible to survey the Wazukhana area except for the Shivling using non-invasive methods as directed by the Supreme Court. The court has now sought a response from the Anjuman Intizamiya Mosque Committee, which manages the Gyanvapi Mosque in Varanasi, regarding this plea. The Mosque Committee has been instructed to submit a counter in the case, and the hearing in this matter has been scheduled for 20th August. You are aware that ASI had already conducted a scientific survey of the Gyanvapi complex and also submitted its report to the Varanasi district judge. The survey report claimed a large Hindu temple existed before the construction of the existing Gyanvapi mosque structure. The Supreme Court today closed a petition challenging a gender discriminatory provision in the Code of Criminal Procedure, taking note of the fact that the statute's replacement, that is, the Bharatiya Nagrik Suraksha Sanhita, has now removed the provision. This petition had challenged Section 64 of the Code of Criminal Procedure, which basically said that if the person summoned cannot be found despite diligent efforts, the summons can be served by leaving a copy with an adult male family member living with him. According to the petition, this section discriminated against women by treating female members of the family incapable of accepting summons on behalf of the person summoned. A bench of Chief Justice D.Y. Chandrachud and Justice Hema Kohli had issued notice in this petition in November 2022. The matter was today placed before the bench of CJI Chandrachud and Justices J.B. Pardiwala and Manoj Mishra. Attorney General for India R. Venkata Ramani informed the bench that the corresponding provision in the BNSS, that is Section 66, does not use the term male, enabling any adult family member to receive the summons. Thus, while closing the petition as infructuous, the bench noted that the Parliament, while enacting the BNSS, has incorporated provisions which redress the grievance. Coming to an update on the hearing of the case filed by Indian Medical Association against Patanjali Ayurveda over publication of misleading medical advertisements. The Supreme Court was today informed that an apology on behalf of the association's president for his controversial remarks regarding the Patanjali hearing had been sent to media and published in IMA's monthly journal as well as website. So if you recall, IMA had filed the case against Patanjali Ayurveda for its misleading claims and disparaging advertisements against the allopathic system of medicines. Later, when despite giving an undertaking before the top court to remove the misleading ads, it continued to do so, the Supreme Court initiated contempt proceedings against Patanjali, its MD Acharya Balkrishna and co-founder Baba Ramdev. During one of the hearings in April, the court also turned the spotlight on IMA, asking it to set its house in order by taking action on complaints regarding the unethical practices of its members. Following that, the IMA president gave a press interview where he reportedly slammed the Supreme Court's observations. In response, Patanjali filed an application in the pending proceedings seeking action against the president for his contemptuous remarks against the court. And on 7th May, the court issued a notice on that application to the IMA president. During today's hearing, senior advocate P.S. Patwalia, appearing for IMA, drew the attention of the court to the apology published on IMA website, which appears as a pop-up. Patwalia further informed that the apology had been sent to media houses, both electronic and print, such as PTI, Economic Times, etc. He added that besides IMA website, a full-page apology has also been published on the first page of IMA's monthly journal. On hearing this, the bench of Justices Hima Kohli and Sandeep Mehta inquired if the respondents had reviewed the additional affidavit filed by the IMA president. When their counsel said that they had not, the bench adjourned the matter to 6th August, allowing time for the respondents to file a reply if they wish to. And now let me tell you, a Delhi court today took cognizance of the supplementary charge sheet filed by the Enforcement Directorate against Chief Minister Arvind Kejriwal and Aam Aadmi Party in the alleged liquor policy scam. Kejriwal, as you know, is in judicial custody in the corruption and money laundering cases related to this alleged scam. Special Judge Kaveri Baveja of Rouse Avenue Courts took cognizance of the 7th supplementary prosecution complaint filed against the Chief Minister and Aam Aadmi Party in the money laundering case. The court has now issued a production warrant for Kejriwal for 12th July. The court also took cognizance of ED's 8 supplementary charge sheet against the accused Vinod Chauhan and Ashish Mathur. The Supreme Court had last year refused to grant legal recognition for queer marriages in India, saying that it is a matter for the legislature to decide. Post that, several review petitions were filed, faulting the judgment for not affording any legal protection to queer couples despite acknowledging the discrimination faced by them. The petitions seeking review of the judgment are listed before the Supreme Court on 10th July, that is tomorrow. In a new update, the petitioners seeking the review have requested the Supreme Court to have an open court hearing of the petition. Senior advocate N.K. Kaul, appearing on behalf of one of the review petitioners, requested the CJI on the possibility of having the review petition hearing in open court instead of in chambers, since the matter involves large public interest. The CJI, however, said that traditionally review petitions happen only in chambers. The review petitions will be considered by a new bench since Justices Sanjay Kishan Kaul and S. Ravindra Bhatt have retired. Justices Sanjeev Khanna and B.V. Nagratna will replace them. The other judges are Chief Justice of India D.Y. Chandrachud, Justices Hima Kohli and P.S. Narasimha. The Supreme Court today refused to recall the cost of Rs 1 lakh imposed on Lucknow-based lawyer Ashok Pandey for filing the petition that challenged restoration of Congress leader Rahul Gandhi's Lok Sabha membership. It may be recalled here that Gandhi's membership was suspended following his conviction in a criminal defamation case over the Modi thieves remark. However, the same was restored after the Supreme Court stayed his conviction in August last year. Pandey had later filed a writ petition contending that Lok Sabha membership can be restored only after the member is acquitted in the criminal case. This year in January, the top court dismissed the petition as frivolous after imposing the cost. The bench said that such petitions only waste the court's time. Today, Advocate Pandey tried to convince the court that he was unable to pay the amount, but the bench of Justices B.R. Gavai and K.V. Vishwanathan refused to consider his plea. Though he persistently tried to continue with arguments, the bench warned of issuing contempt. Let me tell you, this is not the first time such cost has been imposed on him. The court has also imposed 1 lakh cost on him for filing a petition challenging restoration of Mohammad Faisal in the previous Lok Sabha. Also, last year, a bench led by Chief Justice D.Y. Chandrachud had imposed a cost of 5 lakhs on him for filing a petition contending that the oath taken by the Chief Justice of the Bombay High Court was invalid as he did not use the word I. The Karnataka High Court today dismissed a PIL filed by a civil contractor seeking action against several state BJP leaders including MP Renukacharya, C.T. Ravi, Tejasvi Surya and Pratap Simha for allegedly making hate speeches. Petitioner Muhammad Khalilullah claimed that he came across the alleged speeches through social media platforms. He had relied on the guidelines issued by the Supreme Court in respect of hate speeches in the Tehseen Poonawalla case. The petitioner sought a directive for the government to broadcast warnings on TV, radio and official websites stating that hate speech, mob violence and mob lynching will have serious consequences. Additionally, he requested the government to take suo motu action and register cases against individuals who make hate speeches and incite enmity between communities. However, a division bench headed by Chief Justice N.V. Anjaria found that the allegations were too general, lacking authentication, and said that the PIL appeared to be politically motivated. The court said that filing of a petition smacks motive other than public interest, and petition of this nature could not be entertained as a PIL. And lastly, the Supreme Court today dismissed a petition which sought to lower the cutoff for the All India Bar examination. Passing the AIBE is mandatory to receive a certificate of practice from the Bar Council of India, which is required to practice law in Indian courts. A bench led by CJI observed that lowering of the cutoff would affect the quality of lawyers who are admitted to the bar. The CJI also told the petitioner in passing to please study. Let me tell you, a recent RTI reply revealed that more than 50% of the candidates failed to clear the 2023 AIBE exam. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Livelaw. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos, or consider becoming a member at just 89 rupees per month.